Serious indictable offenses are decided by juries, members of the public who are randomly selected to hear a case and decide on the verdict. There are usually 12 people selected to serve on a jury through a process called impaneling. A jury panel is a group of citizens who are selected for possible inclusion on a jury. If the case is controversial, the number of potential jurors included in the jury panel increases. Although each individual province and territory may have its own additional criteria, a potential juror must have these qualifications. He or she must be a Canadian citizen of at least 18 years, must be a resident of a province or territory for at least 1 year, must be fluent in English or French, and must be mentally competent. The following people are usually exempt from serving on a jury: politicians, judges, justices, lawyers, and law students, doctors, coroners, and veterinarians, law enforcement officers and their spouses, people who are visually impaired, people with certain mental or physical disabilities, people who have served on a jury within the previous 2 to 3 years, anyone convicted of an indictable offense without a pardon being granted. People may also be excused from jury duty if they can convince the court that they have a specific reason. During the screening of potential jurors, the Crown and the defense have an opportunity to ask a series of questions, which commonly include: are you a Canadian citizen? Are you fluent in English or French? Have you been convicted of an indictable offense for which you have not been granted a pardon? What is your occupation? Do you have a mental or physical disability or medical condition that may interfere with your ability to serve as a juror? Have you been summoned for jury duty in the last 3 years? There are 3 types of jury challenges that the Crown and the defense can use to accept or eliminate a prospective juror. There is a challenge of the jury list, a challenge for cause, and a peremptory challenge. The Crown and defense may challenge how valid the jury list is, but this is rarely done. If either side can prove that the list is fraudulent or biased, a challenge of jury list may be successful. For example, the accused is of Aboriginal descent. The 100 prospective jurors who have been impaneled are all Caucasian. The accused feels the jury list is unfair and challenges its validity. A challenge for cause can be used by the Crown or defense when they wish to exclude a potential juror for a specific reason. A challenge for cause is usually based on the belief that a juror has some type of bias, for example, racism, sexism, religious discrimination. For example, the accused is Jewish and his defense lawyers believe a prospective juror is anti-Semitic and can prove it. This type of challenge may be used as many times as necessary. A peremptory challenge may be used by the Crown or defense when they wish to exclude a potential juror without a specific reason. Peremptory challenges are often based on the gut feeling of the lawyer or as a strategy. For example, a woman accuses her boyfriend of aggravated sexual assault. The Crown wants more young women on the jury than men and may use peremptory challenges to try and achieve this goal. This type of challenge has limits depending on the severity of the crime. The most serious charges provide the Crown and defense with 20 challenges each, which is the maximum. After being selected to serve on a jury, each juror takes an oath to arrive at a verdict honestly and is sworn to the jury box. Jurors cannot discuss the case with anyone outside of the jury, follow media reports of the case, disclose any information from their deliberations even after a trial is finished. The jury's final decision on the case is the verdict, and it must be unanimous or else the jury is hung undecided. In controversial cases, a jury may be sequestered, that is, isolated, until the case is over.